My name is Justin Steil. I'm an assistant professor of law and urban planning in the Department of Urban Studies and Planning here at MIT. My research focuses on urban inequality, social stratification, racial justice, particularly the ways in which power is exercised through control over space, or the spatiality of power. And I draw on law, sociology, a little bit of political science in looking at urban issues and planning problems. In terms of collaborating with other parts of the Institute, I think the work that I do in environmental justice overlaps a lot with the whole environmental solutions initiative here at MIT and a lot of the environmental work in Earth and Planetary Sciences, Earth, Atmospheric and Planetary Sciences, and a number of other departments. Together with several other faculty and PhD students, we've organized a symposium on fair housing and civil rights this semester. And it's a particularly opportune time for that because the Supreme Court last summer decided a case called Texas Department of Housing and Community Affairs versus the Inclusive Communities Project, which was addressing the question of whether disparate impact liability was viable under the Fair Housing Act. And they affirmed that it did, which is a very important civil rights tool for combating housing discrimination. And then also last summer, the Federal Department of Housing and Urban Development released a new rule about what it means for local governments to affirm really further fair housing as required under the Fair Housing Act. And there's a lot of uncertainty at the moment about what this new rule means for local governments and for community developers and for residents of cities and suburbs across the country. It's been very controversial, and we thought it would be a good idea to bring together scholars, practitioners, policymakers, community developers, state officials, federal officials to come talk about what this new rule means and how what's likely to happen as it rolls out. So the bigger picture for all of this, of course, is the long history of racial segregation in the United States, which is one of the characteristic features of the U.S. metropolitan structure and has been for over a century. Segregation, of course, was increased dramatically at the beginning of the 20th century, the end of the 19th century, beginning of the 20th century, through white mob violence against integrated neighborhoods and black households moving into white neighborhoods, through laws that cities passed explicitly mandating segregation by race in residents, prohibiting whites from living on blocks that were predominantly black and African Americans from living on blocks that were predominantly white. It was then enforced through racially restrictive covenants attached to people's deeds. Then it became a fundamental part of the mortgage lending system, the Homeowners Loan Corporation, in thinking about federal insurance for mortgages, evaluated the underwritability of neighborhoods in part based on their racial composition and famously drew red lines around neighborhoods that were predominantly African American or often predominantly Mexican or interracial, and basically said that those mortgages wouldn't be insured, which meant that it was difficult, if not impossible, for African Americans and Latinos to access mainstream mortgage financing for decades. And so we came into the 1960s with the momentum of the civil rights movement, but in a nation that, as the Kerner Commission described it, was two nations separate and unequal.